and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Judge Milkey. To my right is Judge Walsh. To my left is Judge Smyth. And together we are your panel for the three cases we're hearing this morning. I want to assure the parties that we have read the briefs and the appellate record. Therefore, we're familiar with the facts and the arguments that are being made, which I mentioned because we would urge you in the time allotted to cut to the chase to the extent possible. That said, if you feel like you've made your points, there's no shame in sitting down. As one of our former colleagues used to say, if you hit a home run, there's no reason to run the bases twice. And with that, I will call the first case of the day, Commonwealth versus Tiberias Albert, 2022 P528. Mr. Benyon.
Mr. Presiding Justice, and may it please the court. So let me first raise with you, if you're not already aware, the SJC came down with an opinion that impacts this case, Commonwealth versus Guardado. This is SJC 13315 that just came down. The court held that the burden is now on the Commonwealth to prove that a defendant was not licensed in a firearm charge. The jury must also be so instructed that the lack of a license is an essential element of the offense. So I'm sure you know prior case holding held that licensure must be raised by the defendant as an affirmative defense. That seems to be no longer good law. I'm sure you're all aware of this.
But that affects only the possession charge, correct?
Yes. So I guess the government asked for a motion to reconsider and to stay the rescript. There we go. And so I think that goes until I think the 25th of this month. So I guess I'd ask for instructions from this panel how you'd like to just handle this situation. If you want to ask the parties to brief.
The short response is there is the equivalent of an automatic stay in effect in our court. So we are actually not asking for additional briefing at this time.
All right. Well, with that, I'll just get to the argument that I've raised in the brief. And this is with respect to the government's witness. In this case, Ms. Aguilar was charged with an offense out of Taunton. And this is kind of odd. I hadn't really ever seen this before. When she testified, the court limited the defense cross-examination to the point that the defense could only raise her charge at the time of the defendant's arrest.
Well, it wasn't just the arrest. It was when she fingered, if you will, the defendant to the police the following day.
Yes.
And when she testified to the grand jury, which I believe was the day after that. So to the extent that you're...
By the time of trial, I don't mean to cut you off.
No, I know, but what I'm saying is to the extent that you're arguing, or your client was arguing that she was trying to curry favor with police, isn't that the relevant time?
No, because by the time of trial, she'd already had the case dismissed. That's relevant for the jury. This is the only witness that saw.
Why? Because the case was dismissed 3 years before the trial.
That's a benefit to this witness.
So your argument is just out of gratitude for having the case dismissed. She stuck with the story she told them while the charges were open?
If that's one way to look at it, sure. But the fundamental idea here is that she is the only witness, right? Nobody else sees the defendant or can identify him. And there are problems with this witness's testimony. These are pointed out in my brief. Number one, the victim, he specifically sees and testifies that the shooter gets in the car and they drive away.
Why is that a problem with her testimony as opposed to just an inconsistency between the accounts?
That is quite the inconsistency, because her testimony was that when she saw him leave the car with the gun, she drives away and she doesn't see him again. She doesn't talk to him again. However, once again, that's a problem because I believe her name is Sylvia?
Sylvia.
She testified that she got a phone call from the defendant later that evening after the shooting, and she heard both Ms. Aguilar and her boyfriend, the defendant's half-brother, on the phone with the defendant. So there are some real problems with this witness's testimony. And had the government, and I'll also point this out, had the government gone forward with the prosecution of Ms. Aguilar, then that certainly would have been used, and had she been convicted, that certainly would have been used to impeach her testimony at trial. And so...
Now, the disposition of the charges against her, Commonwealth says this is an everyday occurrence. This is not a particular unusual result, a dismissal with a payment of hundreds of dollars of court costs. What's your response?
Maybe not. But the defense still gets to raise that in front of the jury when it's the star witness for the prosecution's case in the superior court. When the defense can attack the government's star witness with that type of either a conviction had the government gone forward with it, or the fact that it was dismissed to show that there could have been, and I'm not saying that there has to be some formal written, we are going to dismiss the Taunton case for the testimony, but that certainly seems to be what occurred. I mean, the government wants to make sure that this witness is happy, that she can continue forward with the prosecution of the defendant. The defense has to attack her credibility.
What do you do with the fact that the docket in the Taunton case says that it was dismissed on the recommendation of the probation department?
That's still the government's. That's still part of the government, and the idea that an ADA would not talk to probation seems a little silly to me. I mean, I understand that these things happen all the time. You push the docket, that's great, but the defense gets to use it in the case.
Well, I mean, the defense gets to use it if there's some connection, if there's some relevancy, if there's some evidence that would suggest that this disposition was a favor, a gift for testifying, that there was some sort of reason. But do you have anything other than just
the dismissal?
The argument itself that a jury could think this, because you could say it, but do you have any evidence that there was anything other than a dismissal on court costs?
No, that's what it is.
Right. Again,
Had the government been allowed to prosecute, and I hope you read the police report. I don't think that there would have been a problem prosecuting this. The government could have gotten a conviction. The defense...
That's the job of the district attorney, the elected official.
Yes, that I think is my point. It is the discretion of the district attorney's office that gets to do these things, and I understand that they do. But once the government decides not to prosecute her, the defense gets to use that to show...
If there are rewards, promises, inducements, but you have no evidence of rewards, promises, or inducements.
There's not a formal inducement that's like reduced to writing. That's true, but I don't think that it has to actually be that. All that needs to be shown is that this witness benefited from the government's dismissal, and that she's the witness. Also, remember, the defendant's half-brother is in the tub in the bathroom when she's arrested.
Let's talk about that, because part of the argument you're making is based on the curry favor inducement part, and part is based on she had a reason to lie to protect her boyfriend. And the nature of the charges she faced aren't relevant to the first point, correct? That there's nothing about the prostitution charge that is related to whether or not she was currying favor or reacting to an inducement, correct? It's the second argument you're making.
The second argument is stronger, but I'm not ready to leave the first argument because, again, had the prosecution gone forward, there would have been a conviction. The witness benefits from the dismissal of the case. I understand that the government is allowed to do that, but the defense needs to show that this is not a credible witness.
But how does her being a prostitute have anything to do with her credibility?
It does tie in. So it ties in because the defense asked her specifically, have you ever used the name Crystal? And she just on the stand said no. The police officer would have come and said, no, that's not true. She told me your name was Crystal.
Now, how is that relevant, though, other than a back channel way of getting in what the judge said you couldn't get in?
Well, the problem with what the judge said was that the problem that I have is that by the time of trial, and I think the difficulty is with, in footnote 12, if you're looking at like Commonwealth versus Hamilton, cases like that, the defendant is entitled to question the witness about a pending charge. But in this case, it wasn't pending. It was, she received the benefit. The government got her to testify. She testified. It's her credibility that's the problem. The defense needs to attack that. She's the only one who saw the shooting. She's the only one who can explain how the defendant's property gets in her car. That's where the bullets are found. The gun is found in a common area of the basement. No gun or anything was found in his apartment. This case rests solely with that witness. And if the defense can't harshly attack her for her credibility, for the conviction, or for the
He doesn't get to harshly attack her. He gets to reasonably attack her, and that may be harsh in some instances. But
I guess what I'm thinking is so in what's the case? Washington, Crawford versus Washington. The idea of the crucible of cross-examination, the idea of putting pressure on somebody to show veracity. That's the idea. That's the fundamental idea of this case and why cross-examination is so important. And you can't just dismiss this because this witness is the sum and substance of the government's case. If she's lying, and it does appear that she is by the victim's own testimony, by one of the girlfriend's own testimony, there are problems. And what the government is trying to do is make sure that nothing bad gets in front of the jury about why this person might not be truthful.
okay, let me ask about Alston, okay, because as you know, part of the defense was to pin this
culprit.
on Alston.
Yes.
Defense could have called Alston as a witness. In fact, there is some evidence in the motion in limine that they were going to call Alston. For whatever reason, they chose not to call Alston. We have no idea why. Isn't that a potential problem in all this?
I don't think so because oftentimes in third-party culprit defense, even when the person is named, they're not going to be called, or they're not often called, or if they are called, they're often going to not testify based on their privilege. And so,
But isn't that a good thing if you're a defense lawyer, if they take the fifth?
you know, again, so I'm an appellate attorney, you know, trial counsel got to try their case, but in the end, that was one of the defenses that was raised in both the opening and closing, and maybe not the best way through the cross-examination, but if you look at the trial as a whole, clearly the third-party culprit defense was that Mr. Alston did the shooting, and that it's his girlfriend who is covering for him, and that they're trying to pin this on his half-brother, my client, the defendant.
So time is getting short. I just want to ask you about the marital privilege issue, because you say the judge should have instructed, or that counsel should have asked the judge to instruct.
Yeah.
Here, there was no direct application of the privilege, correct? Because Alston was not a defendant.
Yes, that is true.
So tell me the argument to the judge that should have been made that, Your Honor, even though it's not implicated here directly, this is why you need to provide.
So the attorney who filed the motion for new trial, I think, goes into that in the motion. But the idea, again, I get as an overall trial strategy was to show that the marriage occurred as a way to skirt them testifying against each other. And I think that's what my client feels occurred, and he wants to make sure that that was raised properly before the jury, and that he doesn't feel trial counsel effectively raised it. That's one of the reasons for the motion for new trial.
Wouldn't the way to raise, I mean, it's in some sense irrelevant what the privilege was as opposed to what Aguiar's understanding of the privilege was. So to the extent it came in, shouldn't he have asked Aguiar what her understanding was? After all, she did raise it in the case against Alston.
Yes, that would have been a better way to handle it. Again, I feel that the third-party culprit defense and the tying all these pieces together wasn't done wonderfully, but if you read the transcript carefully, you can see where trial counsel was going, and it was a good defense. It's a good defense. It should have been better raised, but it was raised well enough.
Thank you very much. We'll hear from the Commonwealth.
Good morning, Your Honors. May it please the Court. My name is Rob Kidd. I represent the Commonwealth in this case. Starting with the first issue, which is the judge's decision regarding the cross-examination of Brittany Aguiar, we need to start with the standard here. We're talking about an abuse of discretion standard and the judge's discretion in curtailing or limiting cross-examination. And as the Court knows, he has broad discretion to do that. In this case, he allowed a lot of leeway to counsel. He allowed counsel to cross-examine Ms. Aguiar on her, the charge, a pending criminal charge as it existed when she testified to the grand jury and when she gave her statement to the police. He could have asked her lots of questions, for example, about how her testimony might have changed since those times at trial, how her statement to the police may have improved when she went to the grand jury, may have improved at trial and so forth. He had a lot of discretion to do that. And he was allowed to talk about, quote, a pending criminal charge. And the judge just simply drew the line at the point where the case was dismissed, and the judge point blank asked the prosecutor, or whether there were promises or awards, or at least the prosecutor told the judge.
Well, what are we supposed to do with that, given that a representation by the prosecutor is not evidence?
I think, well, in this case, it's not evidence, but I think the judge needs to factor that representation into his discretion as to what to allow and what not to allow. So if the prosecutor had been equivocal or said that there had been some, obviously, that's why it's relevant. I mean, it doesn't come in at trial. It certainly doesn't come in at trial, but that's a common thing that happens in the district, in all the courts, that the prosecution answers either orally or in writing that there have been no promises, rewards, or inducements. In this case, it's also important to know that this, as I said in my brief, this Brittany Aguiar certainly does not act like a person who is trying to curry favor with the government. She has to be picked up by the police in order for her to give her statement to identify the defendant. She wants no part of it. She tries to leave the police station.
And in fact, did leave the police station,
yes,
didn't she?
Yes.
And then she called Alston and then came back.
Yes, I think she did, yes. She came back and then gave a statement to the police. As I said, the judge did not abuse his wide discretion in limiting the cross-examination in this way. He said she may have been under the influence of trying to help herself while the charges were pending. And as I cite in my brief, there are cases that talk about the fact that a witness's gratitude for past favors for the government is not as compelling as pending charges. And there's a line of cases, and the cases that I've seen, most of them, or all of them, talk about pending criminal charges.
Could we talk about the substance of the charge? And this is a case where Commonwealth put Aguilar on the stand, asked her what she did, and she said she was a nurse's aide. Jury doesn't get to hear that she's in fact working as a prostitute, that Alston is her pimp, who's hiding in the bathroom, presumably as security, while she's seeing her clients. If you were a juror, wouldn't you want to know, at least once Alston is placed at the scene by Sylvia's testimony, that Alston, in fact, was her muscle and not just her boyfriend?
I respectfully, Your Honor, I don't, maybe you can explain it to me. I don't believe that that has any relevance to the issue at hand. I mean, it's actually kind of smearing her reputation, and I think the judge looked at it as, it's sort of a sleazy charge, and the jury could very well be carried away by the fact that, or be emotionally swayed or morally swayed to say.
The relevance here on this issue isn't the Curry favor, it's that the third-party culprit on which the defense is trying to pin this on is in fact working as her security. So it's really, it relates to Alston's job, if you will, as opposed to the fact of what she is doing. So it's not smearing her, it's relaying to the jury facts that are potentially relevant to the third-party culprit.
If he's working as her security, I don't see how that makes it more likely that he's the third-party culprit in this case. I just don't, I don't see that. And maybe I'm being obtuse.
I think the argument is that there's a certain degree of violence that may accompany prostitution.
Okay, and I think that goes to, now the argument is even more attenuated in the sense that we're now saying that Alston is a quote-unquote violent individual with propensity to commit violent acts, therefore he's
what's he doing in the bathroom?
I have no idea. Obviously, we don't know what's going on. He's probably hiding from the police who are coming in to raid the place. That's what I got from the police report. But I just think that the judge made a valid judgment, a perfectly fine judgment call in keeping out this sort of sleazy prostitution evidence and the details of this prostitution charge. I could see.
Can I interrupt for a moment?
Yes.
Let's just say the one witness was an off-duty police captain. You'd get that in, wouldn't you?
Who was an off-duty police captain?
One witness to this crime.
To the prostitution crime?
Well, let's just say that it's not her. That she's gone. I'm going to replace that witness with someone that is a 30-year veteran and a captain in the police department.
And
that evidence would come in, and the background and training, and the jury would have at least considered, well, this is what this person does, and this is why we trust what he or she says as true, because of all the reasons of who the person is. So instead, we have a person who is doing something illegal, right? She's engaged in prostitution, and the jury is instructed to use your common sense and life experience or knowledge. Why is it that we're allowed to hide that from the jury and then prevent, when it's connected to a third-party culprit, prevent counsel from even just planting the seed?
Again, because, first of all, a person's occupation, what they do, is something that obviously it's an introductory thing that we ask people, what do you do for a living? Yes, I'm a police captain, so on and so forth. He's no more of a credible witness to the jury just because he's a police captain, or at least that's what the instructions tell us. We're not supposed to evaluate anybody differently because of what they do. He's not more likely to tell the truth because he's a police captain.
So why did the Commonwealth ask her profession?
What's that? I'm sorry?
So why did the prosecutor ask Aguilar's profession at the beginning of her testimony?
Because it's, as I said, it's a routine question that we ask of every witness. And, she's not going to say, I'm a prostitute, or, and we don't know that was a profession, obviously. We don't know, if that was one, but now I'm losing my train of thought. The difference is, Your Honor, is that there's a prejudice in our society against prostitution in general. And against that illegal crimes, and there could be a moral bias against Brittany as a witness just because she's a prostitute, and the thought that, well, prostitutes are just immoral people who are not going to tell the truth. That's not the same as saying someone is a biased witness or an unreliable witness because she's engaged in prostitution. Maybe there's also an assumption that a lot of prostitutes are engaged in drugs. This is the kind of judgment call that Judge Veery had to make at the motion hearing in deciding, is this relevant? How much is this going to show? And is the jury going to be prejudiced by it? Alston, defense counsel still got in the fact that Brittany and Alston were partners, that they were married, that they loved each other, that they were an item at the time that this happened, that Brittany had a motive to protect Alston. All of that came in at trial. Adding the fact that she was with him in a prostitution scheme, I suggest would have been a dangerous road to let counsel to travel down in this case. Well, I would have, well, for what it's worth, I would have made the same call if I were on the bench. But so that's the first issue. I don't know if the court wants me to move on, or I could rest on my brief.
Just to add on maybe another layer, I think the point is that she may be more likely to testify in a way favorable to Alston if the relationship were as it was described in that police report as opposed to boyfriend-girlfriend. There's a level of coercion in these relationships, a level of fear in these relationships. And here we have the jury, again, didn't hear that. So I don't mean to be pounding the same nail, but there are some layers to it. And I feel like the jury didn't get the complete picture of her relationship and potentially her motives. Do you care to comment on that?
Okay, so the argument, what Your Honor is saying is that there was some possibility that he may have been an abusive person who was threatening her, and that she was under threat from him, and that's the reason. Well, she fingered somebody else. That argument was not made to the jury. Well, I understand it couldn't have been made to the jury. Again, I respectfully think that that's speculation. I think that's speculation. I don't think that we can't have the jury go down this road of this is what prostitutes are like and this is what pimps are like. That's just the wrong road to go down, with all due respect. That's my opinion.
Hearing no further questions, thank you very much. The case is submitted. Our next case of the morning is a partially impounded case, JP versus TO, 2022 P709. The counsel can use the initials if they want. Speaking from personal preference, I think plaintiff and defendant would be easier to follow.
Good morning, Your Honors. If it please the court, my name is Jacqueline Darty, and I represent the defendant, TO. I will refer to them as defendant and plaintiff in this matter. This matter arises out of an ex parte entry and contested extension of a civil harassment prevention order out of the Somerville District Court that was entered in May of 2022. I'm just going to...
Just to clarify, has the order in fact expired? It was not extended?
It has not expired.
It has not expired?
It has not expired. It was extended in December. I'd like to highlight for the court, before I get into the bulk of the argument, that there are 8 really salient points that indicate how the district court's decision was made in clear error. First, the civil harassment statute, Mass General Laws, Chapter 285E, requires proof of 3 or more acts of willful and malicious conduct aimed at a specific person. Second, the plaintiff herself testified under oath at the May 2022 hearing that the defendant's contacts with her had not been malicious, had not been abusive, and had not been intimidating. 3, the record evidence demonstrates that in June of 2020, 2 years prior to the harassment order hearing, the plaintiff's father asked the defendant to stop texting her, and he did. And all parties admitted that the defendant and the plaintiff had absolutely no contact for over a year, from June of 2020 until August of 2021. The plaintiff also testified that between August of 2021 and the hearing date in May of 2022, the parties exchanged a handful of friendly texts, the entirety of which are contained in the record appendix and were attached to the affidavit of the defendant, and the court had that for its review. And none of these texts were malicious. The plaintiff herself testified that none of those texts were malicious. The plaintiff also testified that that handful of texts contained in the record was the only contact she had had from the defendant in the prior 2 years. 5th point, at the May 22 hearing, the plaintiff did not allege, and the district court did not consider, the various sexual and criminal acts that are enumerated under the 3rd definition of harassment that's found in 285E. 6, even if the district court had considered those various sexual and criminal acts, the plaintiff's claims would fail because the criminal harassment statute also requires definitive proof of 3 malicious, willful and malicious acts aimed at the plaintiff. We know from the plaintiff's own testimony there were no malicious acts that occurred at any point in time, never mind 3 of them. 7, in her brief, the plaintiff makes numerous conclusory allegations unsupported by fact or law, misstates and misquotes the lower court record and transcript, and fails to meet her burden of proof. And 8, the district court committed clear error because it failed to enumerate any factual findings when the record itself does not support an entry of the harassment order and is insufficient for this court to find that it did. Taking a look first at the first point, that the civil harassment statute requires 3 or more acts of willful and malicious conduct. The Supreme Judicial Court in O'Brien versus Borowski found that whether you're looking at civil harassment or criminal harassment, you have to prove 3 distinct acts that are willful and malicious. Malicious is defined in the statute as characterized by cruelty, hostility, or revenge. The record shows that there is not a single act from the defendant directed to the plaintiff that is characterized by cruelty, hostility, or revenge. And again, I go back to the plaintiff's own testimony. I asked her, and I'll just, if you'll...
How about the one incident of threatened self-harm?
Yes, so if we take a look at that, one thing that I think is really important and is missing from the response brief of the appellee is the time frame here is really important. So the plaintiff and the defendant grew up together on the same street in the same neighborhood. From their front doors, they can see each other's homes. They were playmates as children. They're freshmen in high school. They're 14, 15 years old. And the defendant admits he made a mistake, thought another girl at his school, not the plaintiff, liked him, sent her a sexually suggestive text message. The text message itself is not in evidence. It was not directed at the plaintiff. He didn't send it to her. And both the plaintiff and her representative admitted at the hearing that he has never directed any sexual messages or conduct towards the plaintiff. So that happens. it gets found out. He starts getting horrifically bullied. The plaintiff doesn't want to be his friend anymore. He's losing friends left and right. He's severely depressed, and he doesn't recall saying this. He doesn't doubt that if she recalls it, it may have occurred. He's a freshman in high school, 14 or 15 years old. He may have expressed some sentiment of self-harm. If that rises to the level of malicious, with the nature of cruelty, hostility, or revenge, it is both 3 years prior to the application for the harassment order, and it is the only event. It is a single event, and the case law is very clear, the statute is very clear, you need 3 acts. After that occurs, the defendant then switches high schools, makes new friends, continues to have friends at both his new high school, his old high school, and the plaintiff's high school, where they all attend various sporting events. He goes into therapy. He's in therapy for, I think, about 2 years. He gets dismissed from therapy. He's doing really well, doesn't know that this continues to be an issue. Again, there's a 2-year period where there's almost no contact, and then there are a few friendly text messages that the plaintiff herself testified were never malicious, were never abusive, were never intimidating.
Let me ask you, interrupt you for a moment. There was some evidence from the plaintiff that the defendant sent threatening messages to her boyfriends and/or ex-boyfriends. You could say literally that those weren't aimed to her, but you certainly could infer that a boyfriend would share a conversation with her if it were threatening. What time frame were those texts? Is the record clear on that?
Yes, the record is clear on that. I would make 2 points. Yes, I think that is a logical inference to make, Your Honor. However, those texts, the defendant testified that he did not make any threats to the boyfriend that would have gone to her. No text messages or messages of this were ever produced in court. The plaintiff herself didn't know what they were. It was just vague that these threats were made. And the time frame, again, would have been well before the 2-year period when the contact stopped and then was just friendly. And it would have been 3 years prior to the application for the hearing. And again, the statute's very, very clear. It has to be conduct that is specifically directed at the plaintiff. And here, the plaintiff did not even say that these were directed at her. Her testimony that's in the record actually says that she would hear from other people things that he would say. Her testimony was vague. She never said what any of these threats supposedly were. At best, this is hearsay. We don't have any evidence of it. And I will also point out there were some text messages that were admitted by the court. The defense objected to their introduction because they didn't have date or timestamps on them. There was no indication of whose phone they were sent from, whose phone they were sent to, who sent them, who saw them, how the plaintiff received them. And the court said that they would admit them for the very limited purpose of saying that it went solely to the plaintiff's state of mind. And with that introduction and that limited admission in evidence, that indicates that cannot be used for anything related to whether or not there was this malicious intent that the plaintiff had a duty to prove and failed to do.
Can I jump in here for a moment and just ask procedurally? And so we have the ex parte order, and then we have the hearing with the notice. And you've explained to the court that there was another extension of the order.
Yes, Your Honor, in December. That is also, the notice of appeal has been filed for that. The transcript is done, and we're waiting for the record to be sent to the appeals court.
Same judge?
A different judge, Your Honor.
So that was my question, because what if in the December hearing, just hypothetically, there were 10 absolute slam dunk pieces of evidence that there has been harassment by this defendant against the plaintiff? So the December one only has life because it rested on the first one, and it goes back to the original application.
Yes, Your Honor. While the two are connected, we can't actually make determinations as to whether the court in May of 2022 committed clear error based on future events in December of 2022. Procedurally, if this court finds that clear error was committed in May of 2022, because the order is still live, the correct procedure would not be to vacate, it would be to remand for further proceedings.
But that isn't before us. You said there's a notice of appeal filed.
Correct, and the other notice of appeal will have to make its way to this court, and they would need to be looked at as distinctly. I want to refrain from making any representations to this court about what was or was not said at that December hearing.
I'm not asking you to, but I'm just asking procedurally.
I was about to, but.
But
If the court would like to hear them, I'm happy to tell you I don't want to offer into evidence anything that's not part of the record from the lower court from May of 2022.
For me, individually, it's not before the court. You're appealing right now the ex parte order and the hearing with notice. So my question just is that if we agree with you and find that there was not 3 instances shown of malicious, willful behavior by the defendant, the remedy is a remand
Yes, I believe that's correct, Your Honor.
because of the existing order that's been extended again.
Well, would it, not to get too technical, but would it be a remand or would it be vacating the orders that are in front of us and then armed with that piece of paper, you could go back to the trial court and say, you should look at what was done later on? I don't know the answer to that.
Yes, Your Honor, I think that that's probably a little bit more sophisticated and nuanced way of making my point, which is because the second extension is still live, the first one, if it were to be vacated by this court, we'd have to go back to that court with that information. It'd be remanded for further proceedings, not to hear that whole the May 22 issue again. If the court wouldn't mind, as my time is getting short, I just would like to make one other point that is quite important. I mentioned this briefly at the beginning. The plaintiff never alleged in the lower court proceeding that they were proceeding under that third definition of harassment that sort of scoops in the criminal harassment statute. That wasn't alleged by the plaintiff. I read through that transcript with a fine-tooth comb. They never even said the word criminal. They never did any of it. They never said true threats. They never said fighting words, none of it. And I very specifically read to the court, I said something to the effect of, I know that the court knows this, but for the record, I would like to state, and I read the criteria that we were proceeding under, specifically the civil harassment statute. Now, even if the court had considered criminal, the case law is not supportive of that. The case law states very clearly that the criminal harassment statute, when it relates to speech, which is what these text messages would be, there are no malicious acts that are even at issue here. And the only question of anything that could even fall under potentially the purview of this statute is that one cry for help as a freshman in high school, and then a complete change of behavior and no contact, a handful of friendly texts admitted by the plaintiff. But if we look at what the criminal statute requires, it says that it needs to be constitutionally unprotected speech. It needs to be true threats, which we don't have any threats here. It needs to be fighting words. We don't have those either. And then on top of that, the plaintiff throughout the brief is saying that the facts here are eerily similar to this court's own case, ASR versus AKA, and they're so easily distinguished. What happened in ASR v. AK is a plaintiff asked a defendant to stop contacting him, his ex-girlfriend. She then proceeded to send hundreds of texts from unlisted phone numbers, from fake emails, trying to get around it. Here, while they state that the plaintiff had blocked him, her actual testimony was she thought she had blocked him. When he's asked to stop contacting her, he does for over a year. Then her parents continue to socialize with his parents. They come over to his house. He has no idea that there's any issue here. And then they have a handful of friendly text messages, none of which rise to the level of the violence that was seen in the ASR case, photographs of cuts made to her body. None of that applies here. There's no true threats. There are no fighting words. And I will just end by bringing the court's attention to the fact that The statute is very clear. You must have, whether civil or criminal, 3 willful and malicious acts aimed at the plaintiff. The plaintiff's own testimony, I'm not even asking that you believe my client was credible, but her own testimony was that he had never been malicious, he had never been intimidating, and he had never been abusive. And that indicates that the district court's decision was made in clear error. Thank you, Your Honors.
Thank you, counsel. We'll
much.
hear from the plaintiff.
Thank you, Your Honors. May it please the court, Alexander McIsaac on behalf of the plaintiff, JP. Respectfully, I'd ask you to affirm the order that was extended in May of 2022.
Before you get going,
Of course, Your Honor.
I need to ask you what appears to have dramatically changed your clients, I'm going to use the plural to sweep in both the girl and her father, changed their perspective was when the defendant enrolled at Bryant. And for whatever set of reasons, that flipped everyone out. By the time of the two-party hearing, the defendant had withdrawn from Bryant, left a $25,000 scholarship on the table. Your clients had gotten, it seems, what they wanted. Why are we still fighting about this?
Your Honor, the reason why we're still fighting about that is that what you said, the key point of why they went into court was that when they found out that the defendant was going to be enrolling in the same school, it wasn't just that he was enrolling and she didn't like it. What she testified to was that she had an emotional breakdown at school. And it rehashed and basically had to relive the terror that she had been feeling with this relationship with the defendant. And while the characterization of it from the defendant's side is that they're very friendly, they grew up together, she testified that she had an emotional breakdown at school the day she found out about that, and that she continued to relive that when she got these text messages, she was going through basically horrible anxiety and breakdowns because of them. And that's why it is. It wasn't that she didn't like that he wasn't going to the same school. Now that he was leaving, everything's fine. I think it wasn't clear at the May hearing, and I'll say that it was a pro se individual testifying at a harassment prevention order hearing. But even though these actions may have just been one act was what caused him to go to court, the fact that he got there, and now he wasn't going to the same school out of state anymore, that doesn't mean that his actions and what they have done to her, the intimidation.
Okay, but help us find 3 acts of harassment here, because speaking only for myself, I'm having a hard time finding any.
No, and I understand that, Your Honor. I would say that specifically the acts of harassment are looking at the entire, as the courts have held, you need to look at the entire course instead of just the individual acts to see how it's affected the person. But specifically to your question, the 3 acts or more would be, one, as Your Honor had mentioned, there is a message that he said, if you don't let me become friends, you don't continue speaking to me, I will harm myself. I think that's very clear and very similar to the ASR case as one act. Another act is the fact that he has threatened past boyfriends or her current boyfriend at the time and shown violence as well. The continued...
What do we know from this record about what he actually said to ex-boyfriends?
I believe, and I was attempting to look through the record appendix, and my understanding was that message was admitted at the hearing, and it was simply, I apologize, I don't believe it was admitted at the hearing. I believe she testified, though, that he had threatened harm to her boyfriend, or current boyfriend, or ex-boyfriend. While that's not the best evidence, of course, and we don't have the specifics of what was said, the fact that he is threatening harm to people who are in a relationship with her, and he's telling others about that, the fact that he is continuously showing up to events that she testified to and making himself known to her at these events is what she testified to.
But we're going back to the 3 examples of harassment. So
I'd say the threat of self-harm is one clear one that shows some malice, hostility or revenge of harassment. Another one would be...
To her or to the third parties?
The one to her where he says, if you do not continue talking to me, I'm going to harm myself. I believe that is one act of harassment at that point. Another act of harassment is the fact that he's sending these messages out to other people, saying he's going to harm them, and knowing that those messages will get to her. But also, I think the course of his activities in general showed that it was more than the 3. The fact that he is showing up to these events continuously, the fact that he is messaging her after.
Aren't they in the same social circles? I realize at that point they weren't in the same school, but from this record, it appears fairly tight-knit community in terms of overlapping sporting events, dances, and such.
And I would say, yes, I can understand that was the testimony coming out, especially from the defendant's side, was that everyone was friendly, and this is a tight-knit community. But what the plaintiff testified to is that she attempted to block him and tell him that not to message, the defendant not to message the plaintiff.
So, but let me back up for a moment. Right or wrong, 258E doesn't necessarily consider the impact upon the recipient. I felt, it's the actions of the defendant. So 3 separate acts by the defendant.
Yeah.
So going to a ball game with 10 people or 10,000 people is not an act of harassment. Even if it's like, oh, gee, he's here again. It's not. So the examples of, putting sugar in a gas tank, continually tracking and following, and so that a person is intimidated. But the record, in my view right now, doesn't support the threatening of the boyfriend. Maybe the boyfriend has his own harassment prevention order if he threatens him a bunch of times and if it's proved with maliciousness and all the rest. But you keep going back to her feelings. It's not that, it's what did the defendant do? And going to a game isn't harassment. What else do you have?
Well, I'd say, Your Honor, it's the entire course of what he did was that what she testified to is, and I think what the defendant harps on, is that before the period where the father asked the defendant to stop, he was continuously messaging her. She did receive those messages, those sexually explicit messages that weren't directed at her, and I'm not saying they are, but the fact that he continued to message her repeatedly after being told not to would be harassment. The fact that
when he was told not to, he stopped for a year, correct?
Correct, and then started again. He did send messages after that showing this need that he needed to contact her and harass her. And what he would message her about.
Contact, yes, but where is the harassment? A text message saying, congratulations on getting into Bryant.
I think it's similar in the ASR case, specifically, besides the one messages about the harm to herself with when they talk about criminal harassment, when they said there's 3 or more acts, they said there was that one instance that she sent photographs of harming herself. But the rest of the acts were also, as Your Honor has characterized them, could be seen as innocent on their own. And that she was continuously messaging him after being blocked, sending him from different social media accounts and other numbers. She was showing up at locations that...
Aren't those facts very different from these facts, where there are 3 or 4 messages from the time he started contacting her again? There are 3 or 4 very short messages saying things like, congratulations on Bryant, and she writes back, oh, thank you, and such. It's hard to see harassment going on.
Oh, and I understand that, Your Honor, that if we were taking, those are the only contacts at all, in those 3 or 4 messages, I don't think that the standard would be met. I understand there was a break in time. I understand that there was a period that he did stop, but when the judge, I think the district court judge in their discretion can look at the full picture, which is that there was a lot of activity before he was asked to stop. And then when he was asked to stop, he did stop for a period and then continued messaging her. And I think looking at the acts of what was testified to, that was driving by her house, even though the defendant said yes.
So they live practically next door, correct?
Yes, but again, what was testified to was it wasn't just he drove by the house once. It wasn't just he messaged me once. It wasn't just that he showed up to a game once. What was testified to is that he continuously did these actions. And while, again, they're innocent actions on their own, when looking at the course of all the activity that was being done, of him showing up to these events, making his presence known, driving by the house, sending these messages, being told to stop multiple times by both the plaintiff and the plaintiff's father, and he did for a period, but then restarting it again, and then going to the
But during
same
that
school.
period, isn't it uncontested that the parents were socializing?
I don't think the record's clear that they were socializing during that period that he asked them to stop. I know they was testified to that they were friendly when they were growing up, that they did go to the same events. I don't think the record's as clear as the defendant made it sound, that it was when the plaintiff's father said, stop talking to my daughter, that they continued to socialize. I think the relationship at that point ended between the two families, but I don't think the record is as clear that that is when they were continuing to socialize. I know the question was asked if the families were friendly with each other and if they did socialize, and there was testimony, I think, from both parties they did. But I don't believe the record is clear that they were continuing to socialize at the time that the plaintiff's father had asked the defendant to stop, or the defendant's father to stop.
The defendant claims that the reason he felt free to contact her again was so much time had passed, everything had sort of gone back to normal, and he thought it was okay to do it. Why isn't that a reasonable miscalculation?
I would argue that it's not, it may be reasonable in the mind of a high schooler, but it's not reasonable in the sense that you have multiple people telling you to stop talking to this individual. And I understand he may have thought in his own mind subjectively this is enough time to continue it, but clearly if you've had multiple people, the plaintiff and the plaintiff's father, say stop messaging the plaintiff.
No, if 10 years had gone by and he writes her out of the blue saying, like to reconnect, bury the hatchet or whatever.
It goes into, I think, the calculus of what happened before, but I think on that, on its own, it's not enough to get a harassment prevention order. I think that's the crux of the issue, as Your Honors have pointed out. It's that this is not a typical case where there is so much abuse or so much actions of like direct
So isn't it
harassment.
exactly the kind of case where you would want findings from the judge on these issues? If it's not so obvious on the face of this what the acts of harassment are and whether or not they constitute harassment, isn't this precisely the case where you would want findings?
It could be a case that you should have findings, but at the same time, I would say that when you look at the full level, I think the district court took this, when they looked at the full level of all the messaging and the relationship even before that period, while Your Honors are correct that in the defendant states there needs to be findings, I think this is a case that while it's not a typical case, it is not a case where the case law talks about, where it was somebody drove by 3 separate times, possibly holding up the middle finger, and I forget the name of the case off the top of my head, but that was the case that talked about there needed to be some findings because it's not clear that those acts are harassment. Here you have a history between these two parties of messaging, of threats of self-harm.
But when you read the transcript here, you can see the wheels or gears turning in the judge's head at the end of the hearing where she's struggling with whether this is enough, and then she finally says, okay, 6 months. We'll go through the fall semester and make sure this has been put to bed. And which is frankly why I, for one, am a little surprised the order was extended, but I don't know the record at the new hearing.
No, and I can understand that, Your Honor. And I understand I wasn't there at the hearing, but you're right, from the transcript, it seems that I think the judge put a lot of thought into this order and thought about these acts and made some good questions of both the plaintiff and the defendant about their relationship and going forward and whether it was needed or not. And I think that actually shows that, to go to your question, that the judge took the time to think about these acts and to know that there was a legal standard that needed to be met and that the judge made the correct decision, not in clear error, to extend this order for just the 6-month period to December 30th, 2022.
So do you agree that if we were not convinced that there were 3 acts in this record, that the procedural outcome would be, since there still is a live restraining order, would be to remand this case back to the district court?
I do believe that's what the case law states, that it would need to be remand, or at least what it implies, that it would need to be remanded for the judge to make those especially if the issue was that there should have been findings made, that the judge would need to make those findings and it to be remanded, or at least to have hearing and to be able to make those written findings or oral findings of what the 3 clear acts of harassment are, if that's what your honors find that there isn't enough. I would, again, argue that I think the judge took the time to think about it, asked a lot of important questions and thought about it, and I think there is enough evidence that, as the case law states, that you do not need a written or oral listing of findings of what the 3 exact acts was not needed in this case, because it's different than the cases where somebody driving by just 3 separate times holding up a middle finger or yelling something out of a car window, and they simply talk about that in the cases. So respectfully, I would ask you to affirm the order at this time, and if there's no further questions, I will yield.
Thank you both very much. The case is submitted. Our next and final case of the day is Varano versus PDJM LLC, 2022 P1038.
Good morning, Your Honor. May it please the Court, Chris Marino on behalf of Appellant PDJM LLC. This is an appeal after a 4-day bench trial. We are asking the Court to vacate the judgment that was enter judgment in favor of PDJM on its counterclaim, count 1, and reverse the enter judgment against Varano on count 1 of its complaint. The fundamental issue in this case is non-payment of rent in a commercial real estate transaction. We're asking the Court to either clarify or modify, depending on how you read DeBella, that the non-payment of rent in a commercial tenancy is a material breach, or certainly not an insignificant breach. We're asking this to be made as a matter of law.
Okay, assume, hypothetically, we were to agree with you that non-payment of rent, at least in the commercial setting like this, is not insignificant. Doesn't DeBella itself say that even when there's a default clause on point and for a not insignificant lease violation, it doesn't automatically follow that there's an eviction or a forfeiture of the lease? That under particular equities, et cetera, it still may be a defense.
Absolutely on the forfeiture ground. I think if you fall, again, the way I think DeBella reads is if it's material, it's per se termination, doesn't matter what the lease says. If it's insignificant, it doesn't matter what the lease says, you can't terminate. If it's in that middle category, you look at the lease. And here the lease would say we terminate. All of those, I think under DeBella, still allows the forfeiture analysis, but that's part 2 of the equation. Part 1 is this a material or not insignificant breach of the lease? And of course the payment of rent is the material breach. It is the very essence of the contract. It is why you lease commercial property. It is, I mean, for a long time, when we went to law school, we learned residential tenancies are on one side, but commercial tenancies are on the other. Parties typically have lawyers. They're more sophisticated. It's a commercial transaction. They know what it means. And the commercial tenancies, the non-payment of rent.
Well, Counsel, you're asking us to adopt as a matter of law, and in this very case, the prior 2 landlords didn't find it material. Not the non-payment, but the late payment.
Well, that's the testimony from the plaintiff at trial was that, but we have periods of time where it was after 30 days payment. The prior landlord said 30 days would be a problem. They would have entered eviction proceedings, and that was the testimony.
Well, again, it's very factually intense inquiry then.
I don't think it is, not when we're talking about non-payment of rent for, again, there may be an instance where it's like a day late, but these are people that are getting notices. There were 15 notices. Every time the rent was paid late, the court found each payment of rent that was late, not each, 15 out of the 18 received a notice of this is not acceptable. Twice it was by lawyers. This goes to the forfeiture issue. But this is not a case where the tenant didn't have the ability to remedy the problem. He was given notice. He was told that this is unacceptable conduct. He was told that if you continue to do this, we will terminate the lease. So on the anti-forfeiture issue, should we allow the forfeiture under these circumstances? The answer should be, again, no, because the tenant has the ability to pay the rent on time. They know what's expected of them. They were given ample opportunity to fix the problem, and they refused to do so.
But the judge disagreed on the equities and makes this point fairly clear in his findings and rulings that even if there had been a substantial violation of the lease under these circumstances and these equities, he would still not terminate.
The judge does find that, Your Honor, but I think the facts that he also finds warrant this court saying that's not the way the law should work, especially when you apply that DiBella framework. And again, there is no definition right now of what it means to be an insignificant breach of lease. And I know I'm jumping back to the first issue, but the court looked at the materiality standards, and that shapes its whole framework. But there's the facts that the court found were just what I said, and I hate to be repetitive of it, but were that there were multiple non-payments, there were multiple notices, the tenant was told multiple times what conduct was expected of it, and that the tenant continued to fail to pay the rent. That, under the case law of the forfeiture, falls in the category where the court is not going to protect the tenant if the tenant doesn't protect itself. The tenant is...
Couldn't there, under all those assumptions, still be sufficient equities that the court says, no, I'm not going to do it? Given the investments the tenant made in the property, given the informal bookkeeping that your clients were engaged in, et cetera, that weighing all these factors, consistent with DiBella, we're not going to terminate.
I don't think under the facts of this case. It may be in a different case, but, Your Honor, where you have 18 times the non-payment of rent, where you have the 15 times the tenant's told what's expected of them, you're in that Cooley analysis where the Cooley, I think, Bisonet case, where the tenant is told of what he's doing and they're just thumbing their nose at the landlord. You're putting the, there's reference, both parties reference the NT House case, which I happened to try 2 weeks ago. These cases have a similar pattern where tenants are now returning to landlords saying, oh, you're trying to evict me? I'm going to sue you for 93A. 2 years later, you have a trial, you have hundreds of thousands of dollars, and all the landlord wants is its rent. And it can't even terminate the lease in accordance with the lease because you have these issues of forfeiture. This should not be a one-time, the tenant's out. That's what the forfeiture doctrine is designed to protect, but it's not designed to protect a tenant who, for 18 months, without any justification, there's no justification anywhere in the record where the tenant's saying, I didn't pay because of this, that, or the other thing. There's no explanation. And we can all understand it happens once. It happens twice. 18 times. During the period of COVID, which the court says it'll look at for the purpose of equity, they were $23,000 in the hole 3 months back. And
what relevance, if at all, was it that the landlord here was also a competitor who wanted to reclaim at least part of the property for itself?
I think there's no relevance to that. The court found the testimony at trial was that's not why they evicted. That had nothing to do with it. The court found that was not relevant. It was not, there was no basis for it. And threw that claim out. As a factual matter, that was a disbelieved story that the tenant was creating to create 93A liability. But it was rejected by the court as the fact finder. But here, the court, look, we're not challenging the court's findings per se. I think the court struggled with this. It's a hard issue. But we have to understand that commercial tenancies, what all parties need in commercial tenancies are to understand the rules of the game. And the rules of the game should be based on the lease and the contract the parties enter.
The lease in your contract, counsel, has an explicit remedy for late payment.
The default clause, all leases have that. But if that's the standard, then you're never going to be able to terminate a tenancy.
No, I mean the penalties on late payment. I think your client pursued them once or twice, maybe.
That's what I'm saying, the 10%. Almost every.
Why is that not the remedy instead of, why is that not, again, the appropriate avenue of relief rather than the extreme relief of forfeiture, which the courts frown upon?
Because the reason, commercial tenants have bills to pay too. The reason why they expect a payment on the first of the month is so they can pay their bills. If you have to chase a tenant and they're a month behind, they're 3 months behind, you have no idea whether they're going to pay in real time. You have no idea whether this is going to default. You have no idea whether this is going to bankrupt your entity and your mortgage company is going to come crashing at your door. Commercial tenants and commercial mortgage, they don't have that same ability to wait and say, oh, kick it down the road. Residential mortgages, they do, but not on a commercial tenancy. So that late fee that's going to get them $50, it doesn't cure the conduct. You're talking about 10% of $1,000 rent over the course of a year. It's not significant to the tenant. It doesn't change their behavior. You have to be able to collect your rent. And that's what this case is about. This case is about...
Well, let me back up for a moment, counsel, because I think this case, what it's not about is, I'm having a hard time understanding your argument that as a matter of law. So like a statute of limitations. If the rent is due by 3 o'clock on Friday, if it's 3:01, then as a matter of law, then it's a material. You ask that it be found material and also not insignificant. If we were to reject that argument.
But,
go ahead.
I don't think it needs to be, if the payment is, I think we even put it on a brief, if it's 3:01, if it's 3 o'clock and you're 3:01, the payment is a material term. The fact that you paid a minute late is probably not a material breach.
That's a factual determination.
But there comes a time where you have the repetitive nature of it, and the period of time we're talking about is not this insignificant, which is not defined, nowhere in the case law. It's not a minute
How
late.
is that a matter of law? I guess I'm having a hard time not looking at it and saying, it depends. It depends on case-by-case analysis of what this amounts to. So if that's the appropriate lens that we view this case, which I suggest probably is, then where is your argument that the judge erred?
So I would answer it this way. If it's, even if you want to say that that may work for materiality, it doesn't work for insignificance. Because we don't have a definition of insignificant, but the common definition of that would be unimportant. Whereas the parties have 3 provisions in here talking about the timely payment of rent, I think is a matter of law, and they typically do. They typically have default payments if you're late. They typically have provisions that specifically deal with what happens if you pay rent. That is not something the parties would say as a matter of law is unimportant. I think you could poll commercial landlords and find that they would all agree that when a tenant pays rent is not unimportant. And so even as a matter of law, you could say the non-payment of rent in accordance with the lease is not insignificant.
Well, we don't have a poll before us. We do have testimony from a prior landlord, though, that said it's standard practice, the 30-day kind of time period for payment.
Right, but we have payments here that are outside that 30 days.
Some are, but some aren't.
Correct. But we're looking at the circumstances here. We have 6 times over the course of 18 months where they didn't pay within 30 days, sometimes as late as 45 or 50. I think 59. There's another case.
So if you win on that, how do you not lose when it comes to the equities? I mean, how do you, what's your argument that the judge erred, even if you find that it is not insignificant or?
You got it right.
Right, it's a double negative.
Yeah, it's a confusing terminology. I think if we win on that, it's part one. We have to win on both of them. I acknowledge that.
Right.
So that's part one. If it's determined that it's not insignificant in the circumstances, then it becomes the forfeiture analysis, and that is, and the case law I think is pretty clear on that. If you have kind of the repetitive conduct where the tenant is apprised of the conduct that's expected, given that notice and an opportunity to cure, it prevents the one-off instance where the tenant, the landlord plays gotcha. If you look at the anti-forfeiture cases, they are almost always instances where the landlord is taking advantage and saying gotcha, where they're, oh, you didn't submit the financial statements and certify them. Well, the landlord doesn't really ask about it and then comes in and says, I want to terminate the lease. They weren't given that notice and opportunity to cure.
What standard applies? Abuse of discretion to the forfeiture analysis?
On the forfeiture analysis, again, my standard would be this is a statement of law, what the law requires. So I think it's a legal question. I think it's an equity, it's a legal question. But that's our position. As a factual matter, the facts that the court found, just apply that to the law. And under the law, it's this notice and opportunity to cure. Under the cases, it seems to be that's what it is. So that would be the argument on the anti-forfeiture.
What's your best case on equity, sir? Because the law, as I read it, seems to require some bad faith. I mean, one case often cited is Finkovich, where the tenant continued to hang laundry in an offensive manner. 1920, they actually went on a view in that case. But the court found that was intentional bad faith.
I would say the Cooley v. Bettignol 1 Mass App Court 515, that's the case where the court says, look, the tenant continued to do it without justification after receipt of fair warning, committed an intentional violation. In that case, it was a non-material covenant in the lease. I think that was hanging signs in the window. And so if you're going to forfeit after the tenant is intentionally taking conduct just to kind of thumb his nose in the landlord's face, that conduct we have here. We have the same conduct here. So it requires bad faith in the context of and I think the cases talk about good faith. We look at the tenant, is the tenant exercising good faith? Is the tenant surprised by the conduct? And in all those cases, you can reconcile it with the tenant is really being surprised with the landlord's position. The landlord is doing something out of the blue. The tenant had every reason to think he was okay. He sent the rent. He submitted the financials. The landlord doesn't say anything and then comes in and says, too late. And the court says, no, we're not going to forfeit on one time. I see my time is up, Your Honors.
I have a question, and my colleagues may as well. Am I right in reading the record as saying that this lease expires in January of 2025 unless extended, and that your clients essentially have control over whether or not it is extended?
You are correct in that.
So we're talking about the period between now and January of 25.
You are correct. By the time the forfeiture comes in play, it's going to be basically 1 year by the time the decision comes out and everything goes through. Thank you, Your Honors.
I do have a brief, well, maybe a question or two. One, you're asking us to adopt as a matter of law the material breach, but you're also mentioned that there's no standard for significance, and you're asking us to maybe adopt or to announce a standard. But isn't the restatement, as relied upon in DiBello, isn't that an analytical framework? I mean, we're not talking about a standard as preponderance of the evidence or clear and convincing. Can't you use that analytical framework to determine insignificance as well as materiality?
I don't think you can. I think it's a materiality standard. I don't think it can be the same. If you've got 3 levels, I don't think it can be the same standard for each of the levels. If it hits materiality, it's not. How are you using the same standard?
It's not a standard, though. It's a framework.
It's a framework.
And in fact, the Arizona Supreme Court has adopted that framework for materiality and for insignificance.
I'm not familiar with the Arizona case, Your Honor, but it seems to me that the framework you're looking at and even the analytics of the restatement as to materiality don't apply to insignificance, and you shouldn't be using the same framework or standards to apply to both of them because they're testing different things and the level is different.
Thank you very much, counsel.
Thank you, Your Honor.
May it please the court. Excuse me. Vincent Pisegna for Mr. Varano. Mr. Varano has been a successful restaurateur in the North End for 20 years. 2003, he started the series of Strega restaurants. There's one in the North End. There's one in the Seaport. They're in various locations. The record was clear. Never once, not once, has Mr. Varano received an eviction notice, a notice to quit, a notice of default, or any of the like from any of the landlords in any of his restaurants, including from the 2 prior landlords in this particular location. Mr. Bisignano testified in favor of Mr. Varano, and there was no evidence of any other prior problems with landlords.
Okay, but once the landlord made it clear that they expected the rent to be paid by the 1st of the month, and it wasn't, what's the explanation there?
Well, that was that was a very big issue in the trial, Your Honor, and the court made a very specific finding on that. And it is a question of fact. And the answer is that he did the best he could in the restaurant business. Their own expert, Mr. Adams, testified that the restaurant business is a tough business, and it's not unusual for tenants to fall behind. Mr. Bisignano, the prior landlord, who was an expert, wasn't proffered as an expert, but testified in response to questions from the court that in the business, 30 days is not unusual. Restaurant business is a tough business. Sometimes you can pay it on the first, sometimes you can't. But the standard in the industry is not to act when it's not due on the first. The judge found that he did the best he could. Mr. Varano did the best he could under the circumstances.
But it's still a lease violation.
Well,
because the judge rejected the argument that it was due on a different date.
Yes, that's correct, Your Honor. He did. Even though there's nothing in the lease that says the first, the court made the finding that it was due on the first.
Okay, passing over the question of materiality to go to the insignificance. Why isn't that question answered by the lease terms itself? Namely, there was a default provision addressing non-payment of rent, and so it would seem that that was an issue of some significance to the parties. So how can it be that this chronic late payment of the rent was not at least not insignificant?
Let me respond this way, Your Honor. Counsel has cited 0 cases. There isn't a single case for the proposition that the chronic non-payment of rent constitutes a not insignificant breach of a lease. Not one single case, not in Massachusetts, nowhere in the entire country.
But doesn't the very nature of insignificance, it's similar to trivial or de minimis, that, you know, at some point, you're talking about a very low bar, and this was pretty chronic and pretty late, and there were some instances where it was over a month late.
Well, the courts tell us how to deal with that, Your Honor. The courts are very clear on this. In deciding what is significant or not significant, you look at the restatement 241.
But restatement seems clear to me that it's talking about materiality.
No, there are cases, in fact, this court decided in the Maniff case, Maniff versus Town of Saugus, that significance is decided by reference to the factors, the framework, as Justice Smyth pointed out. The framework, there's not standards, it's a framework for deciding what do you look at to decide whether 1 week is significant or whether 2 weeks is significant or whether 3 weeks is significant. And this court in Maniff was very clear on that. They cited the DeBella case on the question of significance. And specifically, they cited to footnote 7 in the DeBella case, which is the restatement, 241 of the restatement. So this court, in the Maniff case, answers that question by saying, to decide whether 1 week is enough, or 2 weeks is enough, or 1 month, or 2 months, you look at the factors in the restatement. And I'm getting ahead of myself, but if you look at those factors, they all have to do with the harm to the landlord, except one. The first, and let me deal with those standards. The first standard is the extent to which the landlord is deprived of the benefit reasonably expected. That's what my brother says you have to do. You have to look at the harm to the landlord. That's the first standard in the restatement adopted by Maniff. The second one is, can the landlord be reasonably compensated for any harm? Again, from the landlord's perspective. The third one is, what's the harm to the tenant? The fourth one is the likelihood that it will happen again. Again, focused on the harm to the landlord. And the fourth one is there any lack of good faith? Is there any lack of good faith by the tenant? And the court couldn't have been clearer on this, page 42. The court specifically found there was no bad faith by Mr. Varano in connection with his performance under the lease.
Maniff is not published, correct?
Unpublished. Justice Carhart authored that opinion, I believe, 2014.
2014, yes, Your Honor, thank you.
I think it's unpublished.
Thank you, Your Honor.
So it has no binding precedential impact.
Well, it may not, but there are other cases. The John James case, 2011, that's by the appellate division of the district court, agreed not binding.
Which has no binding precedential impact on us.
Well, it doesn't, but the court in that case, analyzed my brother's argument, the very argument he made.
Take DeBella, okay? I mean, DeBella is if I'm wrong, tell me if I'm wrong, the clearest statement from this court or the SJC about how to read the restatement and what it means. And why isn't the defendant correct that DiBella sets a three-tiered test and explicitly recognizes that insignificance is not the same as materiality?
That's right. I don't disagree with that, Your Honor.
So what are you saying? That it's, even though it's a different threshold, the same analysis applies?
Same factors. The same framework is applied, and materiality is a higher standard or lower standard, depending on how you look at it, and significance is a higher or lower standard. But you look at the same factors, the same 5 factors that DiBella says a court is to look at. The judge followed it assiduously. He talked about the architecture of his analysis. I thought a very elegant proposition. And he talked about, number 1, is there a breach? Number 2, is it material? If it's not material, then you're done. Number 3, is it significant? Because there's a default clause in the lease. And number 4, even if all the top 3 are yes, is there anti-forfeiture relief that the court should issue? And what he decided in this case was, he said—
Before we get to, are you going to equity? Is that where you're headed?
Not here, no.
Okay, I'm sorry. You may continue.
And the judge followed it assiduously when he did his analysis. And he never got to anti-forfeiture except in the alternative. What he said was, if you look at the cases, if you look at the restatement, if you look at DiBella, if you look at the architecture of the analysis, and you go 1, 2, 3, 4, number 3 doesn't make it, because you look at those 5 standards, and the court very clearly, maybe he wrote a 50-page opinion, very clearly analyzed.
For the insignificance, DiBella cites cases of accidental, like Justice Milkey says, de minimis type infractions, accidental, inadvertence. What case do you have that would support, again, this chronic late payment, as well as the violations of code or the violations with the furnace and with the chimney duct? What case do you have that comes close to saying that that nature, that degree of noncompliance or that degree of breach is insignificant?
Let me answer it this way, Your Honor. Number 1, it's a question of fact for the fact finder. Number 2, the Tea-House case. The Tea-House case was 6 months.
That was a Superior Court decision?
Yes, Your Honor, it was. Business litigation session, Judge Ricciuti, 2021.
And that was that non-payment, though?
It was a non-payment case. 6 months, Your Honor. And the court said it was an issue on summary judgment, and the court said, this is a question of fact, I'm going to send it to the jury. And that's what all the cases, if you read the cases, they all talk about it's a question of fact, it's a question of fairness, even under the significance standard, under the architecture set forth in the restatement 241.
So the standard be clearly erroneous, since it's a factual determination?
Correct, absolutely, Your Honor. I have a string cite in my brief at page 17. It's a question of fact. This is a question of fact. And my brother can cite to 0 cases.
Actually, I don't think we're disagreeing. It's a question of fact.
Okay.
I think the question I was asking is, in what case does the court look at facts that are anywhere close to the nature of the conduct which we have here and find it insignificant?
I would say the Tea-House case comes closest. Banco de Brazil
Tea-House was a
federal
jury,
case.
though. You said.
I'm sorry, Your Honor.
I thought you said Tea-House was a jury case.
Tea-House was a summary judgment case, Your Honor. Judge Ricciuti in the business litigation session. But there are also facts, there are bad facts on the landlord side of this case, and I think that influenced the court. He doesn't say it, but he does. When the Federolis purchased this property, their plan was to take over the restaurant, Nico's Restaurant. There's a beautiful,
Fine, that, though.
he did not. I would submit it was a compromise decision by the judge on that. Because the record was clear. He submitted a color-coded plan for taking over Nico's. The VP senior loan officer has in his notes, federally protected notes, has a whole explanation of what their plan was. He included the plan when he submitted to his superiors, the loan committee, what was going to go on here. And as it turned out, they were never able to effectuate it. But they submitted it, they proffered an expert at trial, and the expert incredibly testified that his job was to find a justification to terminate the lease. Experts don't do that. Experts go and they evaluate situations and they use their experience to render an opinion, not to find a justification to terminate the lease. Ms. Frattaroli testified she was concerned that her insurance was going to be canceled. Well, the fact on that, the evidence on that was that the report went to the landlord. The landlord sent the certificate of inspection from the city of Boston and said to Mr. Nobile, the insurance agent, "Is this enough?" And he says, "Yes, that's fine. I don't need anything else." He forwards that to Ms. Frederoli. She says, "No, that's crazy. Send it back. Tell them that they haven't satisfied what you require, and tell them it's going to raise my insurance premium." And sure enough, Mr. Nobley duly does that. So there's plenty of evidence here that there was some bad faith on the part of the landlord. And I think that informed part of the judge's reason for coming out the way he did, in addition to the incredible loss to Mr. Varano in the event that he lost this lease.
Let's turn to the forfeiture issues. There was an opportunity to cure in terms of conforming conduct to the lease as it was interpreted by the judge. The defendant characterizes this as similar to the thumbing of the nose to some of the other cases. Your response is that your client did the best it could. If, assume for the sake of argument, we were to determine that there was a significant or not insignificant violation of a lease term through the chronic late payment of rent, what's your best case on the equities that there still shouldn't be forfeiture?
Oh, God, Your Honor, there's so many of them. There are plenty of anti-forfeiture.
Give us a few.
Well, there's the Judkins case, an SGC case.
When I say best case, and in this instance, I don't mean
best case
one
of
of
fact.
these. I mean, what's the strongest argument? I should have been clearer.
Thank you, Your Honor. Sorry. Well, Mr. Varano invested over $500,000 in this, did an incredible build-out. He, at all times, paid the rent. At the time they sought to terminate the lease under the notice, they were paid up. The lease was always paid up. It was late. It was chronically late, but it was always paid every single time. He did his best to do what the landlord wanted him to do. There's a whole half of this case that my brother's not pressing, where they claimed that there were all these conditions defaults in the premises, and they brought in an expert. Oh, I see my time is almost up. That there are all these conditions defaults, and the court found out either there weren't any or they were insignificant. So on the balance of the equities, I think I would look to the quote by the judge about Anna Frateroli, who was the principal of the landlord, who said, "The milk of human kindness does not flow through the veins of Anna Frateroli." And that's the way the whole relationship was dealt with by the landlord. And I think he felt that Mr. Varano did the best he could, always paid the rent, albeit late, did a good job, put a lot of money into the restaurant. It was branded as a North End restaurant. He would lose his branding. He would lose all the value and the goodwill that he put into it. And on the other hand, you got a landlord who's probably looking to take the premises to give it, to take it over for their restaurant, Lucia's, eventually. So I think on the equities, Your Honor, forfeiture, the forfeiture is a very easy case.
You have 30 seconds to use however you would like.
Thank you, Your Honors. I'll waive my 24 seconds.
Okay, I just want to say one thing, and that is, this is a very interesting case. Looks like there's not a lot published in the appellate courts. We will do our best in resolving the case and the issues that are presently before us, and we will try to do that relatively quickly. That said, we do not mean to inhibit any further conversations the parties may want to have. It looks like this lease is going to be up in essentially a year and a half, and
May I recover my 24 seconds, Your Honor, to respond to that?
no, you're going to say that there's an extension provision and that they have to bargain in good faith over that. So we know what you're going to say. When we issue our ruling, at least one of you is going to be very unhappy. It could be both, to the extent we send you back for further proceedings, that would probably outlast the lease provisions. All I'm saying is, while we do our job in terms of resolving this appeal, we do not mean to prevent you from doing your job in terms of looking to what might be in your client's mutual best interests. So with that, the case is submitted and we are adjourned. Our thanks to the court officers and the law clerks, and we are concluded.